Good afternoon, and welcome to today's Regulatory Transparency Project webinar titled Exploring Tradeoffs, the Nexus Between Antitrust and Security. We're so glad that you're able to join us today. My name is Elizabeth Dickinson, and I am an Assistant Director with the Federalist Society's Regulatory Transparency Project. In order to get right to the discussion, our moderator will start off and provide a quick framing of the discussion, and then our panelists will each briefly introduce themselves and their position. Our moderator today is Brandon Pugh, Policy Director and Senior Resident Fellow of Cybersecurity and Emerging Threats at R Street Institute. You can find more about today's moderator and panelists at fedsoc.org. That is fedsoc.org. With that, I will hand it off to you, Brandon.
No, thank you, Elizabeth. Of course, thanks to the Federal Society and the Regulatory Transparency Project as well. You guys do exceptional work. Like Elizabeth said, I'm Brand Pugh. I'm the Cybersecurity and Emerging Threats Policy Director of the R Street Institute. We're a nonpartisan think tank here in DC, or wherever you may be listening from, I should say. I'm looking forward to our panel today. We're going to be exploring how antitrust efforts and security intersect. And it seems like antitrust efforts have seemingly become more prevalent recently, and they don't always follow party lines. For instance, we've seen actions in courts recently, like the US versus Google case, increased attention by the Justice Department, and Congress as well has taken a look at antitrust as well with the American Innovation and Choice Online Act, just as one example. And at the same time, we've seen international efforts. However, arguments generally revolve around the merits of antitrust action itself, but generally don't focus on the implications of cybersecurity, national security, and data security. And we can see these, arising directly or perhaps indirectly. But it's imperative to carefully consider these impacts to ensure security is not negatively impacted. We're going to hear from three experts to explore these implications: Jamil Jaffer, Klon Kitchen, and Tom Lambert. Like Elizabeth noted, they're going to introduce themselves. I'll ask some questions to kick us off, but we also want to hear from you. So definitely encourage you to put your questions in the Q&A feature. We'll leave time at the end and also address them as they are relevant during our conversation. So to get us started, Jamil, do you mind introducing yourself and how your work interacts with today's program?
Yeah, thanks, Brandon. Thanks to Elizabeth and Klon and Tom for being here today. My name is Jamil Jaffer. I'm the founder and executive director of the National Security Institute at George Mason University's Antonin Scalia Law School. I also run NSI's Cyber and Tech Center. In my free time, I am a venture capitalist at Paladin Capital and previously was a cyber operator at a startup run by the former director of NSA. Back over to you, Brandon.
Thanks, Jamil. And Klon, we'll turn it over to you.
Good afternoon, everyone. My name is Klon Kitchen. I am Managing Director at Beacon Global Strategies, where I also lead our firm's global technology practice. Prior to that, more than 15 years in the U.S. intelligence community, was National Security Advisor to now former Senator Ben Sasse, and I am also a non-resident senior fellow at the American Enterprise Institute.
Thanks, Klon. And Tom, if you don't mind.
Great. I'm Tom Lambert. I'm a law professor at the University of Missouri Law School, where I teach antitrust law. That's my primary area of scholarship at Mizzou. I have studied most of the pending antitrust cases around big tech platforms, some of the legislation that's been proposed for digital platforms like the ICOA statute that Brandon mentioned. I should note at the outset that unlike the other two guys on the panel here, I am not an expert on national security or data privacy. I'm very excited to learn from them about those matters. I'm really an antitrust expert, so my role on this panel is to provide sort of color commentary on the antitrust aspects of these big pending cases.
No, I think it's a great perspective, and I'm actually thrilled with the composition of the panel because likewise, I'm not an antitrust expert per se, but love looking at the security implications. So it's nice to see we're well-rounded. But perhaps just to dive right in, I kind of teed up US versus Google. That's probably, I guess, the most timely case we see dealing with an antitrust action. Do you mind, Tom, walking us through, what is this case for those who haven't followed it since its inception, and where are we now with it, including some of the proposed remedies?
Sure. Well, I should specify that when we talk about US v. Google, we're talking about the Google search defaults case. There's another case pending against Google about its ad tech stack, and the trial has occurred in that case, but we haven't gotten a judgment yet. But this case was a lawsuit that was filed by the Trump Department of Justice back in October of 2020. Sometime a couple years before that, the Federal Trade Commission and the Department of Justice had sort of split up the major tech platforms, the GAFA firms, Google, Amazon, Facebook, and Apple. And the Department of Justice took Google and Apple, and the Federal Trade Commission took Facebook and Amazon. And now there have been lawsuits brought against all four of those platforms, but this was the first big one to be filed. It alleged that Google had engaged in illegal monopoly maintenance of two markets, the general search services market and the general search text advertising market. So you can think of that as Google search, and then the ads that show up as search ads when you make a Google search. So specifically, the government alleged in this case that Google had maintained its monopoly by paying to have its search engine, Google Search, be the default search engine on various search access points. So you can think of those as just places that you as a consumer might use web search. So in this case, the court or the complaint was focused on iPhones and iPads. You know, Apple sets Google Search as the default search engine on its mobile devices. Android devices, the OEMs, original equipment manufacturers that produce Android phones, and the telephone service carriers that provide service for those phones are paid a fee by Google to have Google Search be the default search engine on those devices. And then independent web browsers like Mozilla's Firefox browser, Google pays a significant amount of money to Mozilla to have Google Search be the default there on Firefox. So the government said that the effect of these default agreements was to deny scale to rival search engines like Microsoft's Bing search engine. That's the primary competitor to Google Search. That denial of scale, in turn, prevented those rivals from developing into formidable competitors to Google. And the idea, of course, is that the more search queries a search engine handles, the better it is at providing search results that people are looking for. I mean, the search engine can see, it serves up a whole bunch of answers, and it can see where people click, so it can tell that's really the most responsive answer to this search query. And the more information it gets, the better its search engine. So by denying its rivals access to a whole lot of search on mobile devices for the most part, the government claimed, Google was preventing them from becoming formidable rivals. So the lawsuit was filed in October 2020. The trial was last fall. It was a 2-month trial before Judge Mehta on the U.S. District Court for the District of Columbia. The trial addressed liability only. So they bifurcated the question of whether Google has violated the antitrust laws, and then what do you do if it has? So we've only gotten now a ruling on liability, but in August of this year, Judge Mehta found that Google was liable for monopoly maintenance in both of these markets. To reach that conclusion, this was a lawsuit that was brought under Section 2 of the Sherman Act. Section 2 requires the possession of monopoly power in a market, an unreasonably exclusionary conduct to maintain or extend that power in some way. So Judge Mehta had to find both of those things, that Google had monopoly power in these two markets, that engaged in unreasonably exclusionary conduct, and then you have to find that the Google's conduct caused it to maintain its power. And he concluded that all of those elements were satisfied, and therefore Google is liable. So the parties are now engaged in discovery on what the appropriate remedy should be in this case. Judge Mehta is planning to hold a hearing on that question in the spring, and he said that he will issue the court's remedial order in August of 2025. Now, turning to the remedies, because I think this is where we're really largely going to focus here. Bifurcating liability and remedies in this case meant that we've proceeded all along without any thought about whether and how the court could actually make things better. Well, now we have to confront that issue, and we're seeing that it's actually a really hard question. So the court here can't just ban all payments for search default status. It can't tell all search engines you can't pay for default status. And the reason for that is the court can only bind the parties before it. So it can bind Google, but it can't bind Microsoft. It can't bind Apple for, and tell Apple you can't accept a payment for Microsoft, etc. So that's not an option for the court. The court also can't impose a choice screen saying, if you have an iPhone, you have to have a screen on the iPhone that allows people to pick their search engine. And again, the reason for that is that Apple is not a party to this case. And so the court doesn't have the ability to tell it what to do right now. Now, what the court could do, of course, is say that Google can't pay for default status. But if it does that, then we're in a really strange world. There's two possible outcomes if that is the remedy that the court imposes. It could be that Microsoft then pays for default status to have Bing be the default search engine on iPhones, Android devices, independent web browsers, etc. But that seems like kind of an undesirable outcome. Microsoft is the world's third largest company. It's $1 trillion. Its market capitalization is $1 trillion more than Alphabet, Google's parent. And so this would really result in this lawsuit subsidizing, a giant company that really doesn't seem to need the subsidy. The other option, of course, is that Microsoft doesn't buy default status on these various search access points, and then the providers continue to use Google as the default. So Apple has said Google is the best search engine. That's the one we would choose anyway. And so we may end up with a situation where Google remains the default search engine on all these search access points, but doesn't have to pay anything for it. So that's a weird outcome because it seems like the bad actor is benefited by this lawsuit. So given that these outcomes, are kind of unsatisfying, the Department of Justice is now scrambling to find a better remedy, and it's really swinging for the fences. So in early October of this year, DOJ filed a statement of its proposed remedial framework. It's not going into great detail yet on what it thinks the remedy should be, but it's giving us a framework. And it emphasized really 5 big things that it would like to see the court do. One is end Google's payment for default status on existing and future search access points. We've talked about that already. I do think that it's worth discussing the implications of ending Google's payment for default status on future search access points. This would be things like sort of IoT, Internet of Things devices, wearables, appliances, home appliances, etc., that are web enabled. If Google can't pay to be the default search engine on those types of products, that does tend to decrease the incentive for producers to come up with sort of web-enabled devices. So I think that's a little bit problematic, but my hunch is that is something we will see in a remedy. Second, the DOJ has said that it will pursue behavioral and structural remedies that would prevent Google from using products such as Chrome, its web browser, Play, its app store, and Android, its mobile operating system, to advantage Google search. So that could result in a breakup of Google, spinning off Chrome or Android or the Play Store. Now, the problem with this is that a breakup of these services could really destroy Google's business model. Google's various pieces cross-subsidize each other. I mean, Android is a free mobile operating system. It's provided to telephone producers, mobile phone producers for free because Google is able to earn money off searches that happen on Android devices. When you start splitting up the company, you prevent this sort of cross-subsidization. And some of these services really can't stand on their own. So that's, I think, a pretty troubling remedy. The third thing, the government says it wants to force Google to pay for educational campaigns about how to switch search engines. Well, I don't think that's a big issue, but I also don't think that that's probably going to have much effect. We've never seen Bing or DuckDuckGo or Yahoo, any of the other search engines, ever advertise how to switch your default. It's extremely simple to do. It's 3 easy steps. They probably haven't done it because it won't make any difference. And so the government may order Google to educate people on how to do that, but it's unlikely that will make a big difference. The fourth remedy, and this is one I think people will want to discuss, the government has proposed to force Google to share the user data that enables it to create such a terrific search engine. So it said it wants Google to have to share the indexes, data, feeds, and models that are used for Google search. Couple problems here. One is user privacy, and I won't say anything more about that because I think my co-panelists will have a lot to say about it. The other thing, of course, is that this sort of destroys the incentive to build or collect your own data and models, etc. And then finally, the government's saying that it wants to prevent Google from getting an advantage in artificial intelligence, to force Google to allow websites that are crawled for Google search, so that are looked at and included in Google search results, to opt out of training Google's AI models or being used for retrieval augmented generation tools. That's when it's an AI term where you have your AI that's trained on all this data, but then it accesses other material to answer questions that it doesn't know the answer to. So the government is seeking to prevent Google from being able to crawl or to use websites that it crawls to provide that service. That could have some significant implications for Google's ability to develop a strong AI product. I'll stop there. I could talk about the appeal, the inevitable appeal if you want to, but we'll save that for maybe Q&A.
No, I appreciate it. I think it was an exceptional overview, and quite frankly, I follow this, routinely. It's hard to get a concise and like actually streamlined overview like you provided. So, and that's sincerely. I think you kind of tee up, at least from my angle, at least 3 remedies I think that are most aligned with potential security implications. So maybe as just to kind of transition from them, like between 2, 4, and number 5 as you laid out, we'll go over to Jamil and Klon just to hear about, like, outside of the competition concern specifically you alluded to, what potential remedies may impact data security specifically?
Klon,
And how would that be done?
Well, look, I mean, I think obviously any of these proposed remedies could have a significant impact on security because they will affect the incentives for these companies to continue to innovate, continue to change their behaviors, to continue to improve their own security, to invest in capabilities. Look, if you undertake, let's just take the most extreme remedy, right? Sort of a breakup style remedy, right? What you're essentially telling companies is, look, if you go down this road and you're highly successful, and in this case, if we find that you violated the antitrust laws, again, there's a debate here that was now litigated and at least been decided by this court. We'll see what happens on appeal, that there was in fact violations of the antitrust laws. But if you're debating that and you're trying to assess ahead of time, hey, look, if I'm going to try to go and grow and be a big, successful, innovative company, right? But I'm going to ultimately get broken up, right? That's going to disincentivize you to do things like invest in innovation, invest in R&D, invest in core cybersecurity, right? And particularly when some of the things you're doing to make your cybersecurity better, for example, sharing information, working with competitors to create better collective security. But if that's viewed as sort of part of the antitrust story, right? That you're collaborating, you're working across boundaries, you're ensuring your market power by being the biggest player in the block, and then enforcing that by either obtaining or sharing information, whatever it is you might be doing. If that's part of the antitrust story, that's also going to make it harder to do those things, right? Whether it's defend yourself or defend the ecosystem, depending on whether you're working with competitors or not. So there's a lot of ways in which a well-meaning and even a traditional antitrust approach. And again, I think there's a lot to say about this case and whether this is traditional and whether the judge's decision breaks new ground or is sort of just a classic application of antitrust law. I don't think it is. But regardless of that, the simple operation of standard antitrust policy, as we understand it, as we've long understood it, could have these implications. They're only enhanced in a case where you're sort of coloring outside the lines, expanding the ambit of antitrust law, expanding the boundaries of where we thought antitrust covered and how it worked, such that it could undermine innovation and undermine cybersecurity as well. And collectively doing that undermines both our economic and our national security by taking our best players off the field at a time when we're in the heat of a competition with a major player like China.
Yeah, I think I'll zero in on one aspect of the proposed remedies that was mentioned. It's the idea of forced interoperability or data sharing. And I just try to get very concrete about some of the security problems that provokes. And I'll break that into two categories. First, threat surface, and then second, attacker sophistication. So on the threat surface. So if any company, a technology company, is forced to maximize interoperability and share proprietary information, what that does is it greatly expands what we call the threat surface. So right now, Google needs to secure itself. It's a massive enterprise, but it needs to secure itself. At the point where critical information is then forced to be shared amongst a broader group of people, well, now bad guys don't need to compromise Google, which is a hard target. They can compromise someone else in that value chain who's further down, who doesn't have anywhere near the same resources that Google has dedicated to cybersecurity, both personnel security and digital security and physical security and all the rest of it. Right. So the point is this is a rough metaphor, but you'll get my idea. So let's say that you have taken extreme measures to secure your home, but then a court rules that you have to build a connective wall between you and your neighbor, and you know that your neighbor leaves their doors and windows unlocked all the time. How are you going to feel about that? That's precisely what the court is proposing Google do. And that's just not wise, and it has inevitable, unavoidable security consequences. On the flip side of the coin, for this proposed remedy is the attacker sophistication. So it is not difficult to imagine a scenario where a foreign company doing business in the United States or internationally would be given this information, as Google has been potentially ordered to do. And it just so happens that foreign technology company has a close association with a hostile foreign government. Let's say it's the People's Republic of China and the Chinese Communist Party, right? And all of a sudden, what we've done is we've essentially given a level of insight and specific knowledge to a hostile enemy or a hostile entity who now understands the nuanced, intricate operations of how Google goes about operating and securing itself. Well, not only is that bad for Google, and it would be catastrophic for Google and all of its users, but Google provides a whole host of services to other industries and even the US government. And so it's not as though that security risk and that expanded attacker sophistication and threat surface is limited in any way, shape, or form just to the company. That then essentially reaches broadly into the entire US system, both commercial and government. And so without getting into the goods or the bads and what has been found and what has not been found in a particular judgment, I'm simply here commenting on the proposed remedies and saying that in a world where securing nations means securing networks, and securing networks means partnerships between the US government and industry, that's unavoidable, that these types of legal rulings, antitrust particularly, has to start factoring in to its proposed remedies national security consequences.
No, thanks, Quan. Yeah, maybe as a follow-up to either you or Jamil. I mean, obviously, one of the proposals we heard could be just a pure breakup and like a spin-off of certain products. So, perhaps, have Chrome or Android be separate, perhaps even separate legal entities. I know some were saying that's more of an extreme remedy, and we're even like downplaying the fact that the DOJ even proposed that, but that's kind of where we are. So I am curious, so like, perhaps are there benefits, and if so, like, what are they of keeping a company like that together? Like, I know like Google has kind of prided itself on offering services and the ability to track and share threat intelligence among its product offerings.
Yeah, well, I mean, I'll quickly jump in, and Jamil, please feel free to kind of fix anything I break. But Tom made the point that a lot of these individual companies aren't self-sustaining, broken apart from the others. Well, that's not just true from a financial standpoint, it's also true from a data security standpoint. So one of the reasons why your Gmail isn't just constantly being hacked is because of the insights that are derived from Google's broader cloud provisions and services, and vice versa. One of the reasons why corporate cloud architecture is not constantly being taken down is because of all the preemptive information and insight that is derived through Google's Gmail monitoring and cybersecurity apparatus. These things are all cross-pollinating, right? There's a reason why these types of fused capabilities are trusted at the scale that they are. And one of the key features that has allowed them to scale to the size that they have is that they're trusted because they're secure. And they're secure because they're interoperable within a particular defined ecosystem, right? Now, I've already talked about how that breaks down once you kind of get out beyond a particular entity. But the reality is that we have a cross-pollinating security apparatus that has proven very, very effective. And at the point where you begin chipping away at the foundations of that apparatus, there's no denying the cybersecurity and national security implications of that.
I think that's exactly right. And I think the other thing to talk about is and sort of, I think Klon alluded to this, is scale, right? So if you have scale, when there's a problem, right, you can rapidly fix it and deploy that fix or that solution across a broad set of customers, a broad set of clientele. So look, at some level, cybersecurity challenges, right, difficulties in this space are inevitable to happen, right? So the question is, how quickly can you address them? And if you have scale and footprint, you can resolve things very quickly. You also identify those things, as Klon pointed out, for all the reasons Klon pointed out, identify those things quickly, but you also have the ability to deliver results, right, very quickly as well. And you can't discount that. And then, of course, there's the larger national security question about when you're going up against a competitor nation like China that doesn't play by the rules, that steals intellectual property, that uses artificial subsidies and low interest loans alike to buttress its own national champions, right? When you have economically successful companies in your marketplace who are becoming successful obeying the laws. Now, again, debate here, right? There's a legal violation that's been determined by the court. But if you're playing by the rules and you're getting there successfully, right, and you're doing it because you're innovating faster, you've got a better product, you've got better capabilities, right? Trying to take those capabilities down by a notch and say, well, we're going to split those up, destroy the very ability you have to innovate by breaking apart the products you've created, and not allow you to cross pollinate in the ways that Kalam was describing on the security side, right? Will ensure that you can't compete against an authoritarian nation. They actually bring together those capabilities, do it behind closed doors, fund it with government dollars, and fund it with stolen intellectual property stolen from the United States at the scale of, billions of dollars a year and trillions of dollars in total.
No, thank you both. Yeah, just remind the audience, it's hard to believe, but we're about halfway through our program now. So encourage you to keep sending questions in through the Q&A feature. And we do have more to talk about in US versus Google. So, and particularly, I want to get at the AI implications. But before we do that, let's touch on a more traditional antitrust question from a listener. Perhaps, Tom, I think you'd be the best person. Kind of going back to your overview, the question word for word is, what about plain old compensatory damages? Is it relatively easy to calculate the gains that Google's enjoyed due to its monopoly status and perhaps act on them in a remedies phase?
Well, sure. So, I mean, one thing to note, this is a lawsuit by the government, and the government didn't seek damages. It's seeking an injunctive relief, but if there were a lawsuit by a private party, compensatory damages are in theory available. Here's the problem, and it actually goes to something that I think is maybe worth talking about, which is a point of vulnerability on appeal. In this case, I mentioned when I was talking about what the court had to conclude to find Google liable, they have to find causation that Google's acts of entering these default contracts caused it to maintain its monopoly. And, that's really hard to do because everyone admitted, and the court concluded, that Google is by far the best search engine. And it's probably what the companies would have chosen as the default, even without being paid, et cetera. And so it's hard to, figuring out like how much did these bad acts contribute to Google's monopoly status is actually kind of a hard thing to figure out. So the court in this case used a really low standard for causation. It did not require, what we call but-for causation, where you have to show that but for the bad acts, Google wouldn't have been able to maintain its monopoly the way that it did. The court didn't require that. It said, were these bad acts reasonably capable of substantially contributing to Google's maintenance of its monopoly, which that's a very low standard of causation. That would not be sufficient causation to establish a right to compensatory damages. But it could give rise to a right to injunctive relief. At least that's what the court said. I think that that's actually quite vulnerable on appeal, because the case that the court cited in favor of that low standard of causation, the Microsoft case, really limited that low standard of causation to one particular situation. That is when you have a nascent competitor who's being excluded from a market. That's a competitor that's not actually in the market, but could come into the market. So in the Microsoft case, it was Netscape Navigator and Java's Sun, or Sun Microsystems Java, that were being excluded. They didn't directly compete with Windows, but they might become a competitor to Windows. And so the court said, since, we don't really, it's hard for us to construct a but-for world, we're going to have this low standard of causation. But the excluded firms in this case are existing competitors. And there's another DC Circuit decision, the Rambus decision, which says that the normal standard for causation is but-for causation. So I think that there's a vulnerability on appeal here about the causation standard. But I also think that going back to the question, what about compensatory damages? I think it would be extremely difficult to show, that Google's acts here of entering these default contracts, how much that contributed to its market share, and then to figure out the money damages stemming from that, I think would be really a hard thing to do.
I appreciate it. Yeah, kind of circling back to AI. It seems like you have to mention AI on a panel these days. But on a serious note, though, it is important. How is AI potentially implicated in this antitrust action? And then, what broader issues might that present, especially around competition with other countries, notably China?
So I think, one of the proposed remedies is that Google cannot use its AI to kind of advantage itself. And I definitely want to pick at that. But that proposed remedy seems to be predicated on ignoring a particular fact and a false presupposition, right? So on the one, I think it ignores the fact that, and I alluded to this earlier, that national security is now a shared burden between government and industry. That actions taken in one context has a direct national security implication, often in the other. And nowhere is that more true, I think, right now than in artificial intelligence. So I think this idea that they can just kind of take an act, cause Google to not be able to employ its artificial intelligence in certain capabilities, ignores the fact that, for example, Google's AI capabilities are part of how it's doing automated threat hunting and mitigation within cybersecurity networks and email networks and everything else. That is to the nation's advantage, right? It's such a narrow understanding of the issue it's just confusing. But then it also, I think, is based on a false presupposition that the DOJ and the way it's talking, at least, seems to be thinking that scale and success necessarily equal anti-competitive behavior. And I think the LLM, the large language model, the kind of bleeding edge of artificial intelligence research, belies just how wrong that is. And here's what I mean by that. Precisely because Google was and is operating at the scales at which it has now, it was able to invest massive resources into research. And one of the outcomes of those research efforts was a paper called All You Need Is Attention. Yeah. And this paper literally is the genesis of the artificial intelligence renaissance upon which we are all kind of riding the wave right now. And I don't think anybody could argue that there's anything but a massive proliferation of artificial intelligence opportunities and offerings in the marketplace, including search. So there are other companies who are now deploying large language models, all built upon the research done at Google, to deploy search alternatives. And if anything, the modern search marketplace is diversifying rapidly and evolving quickly. And that is all because of Google at one point operating at scale. And so I think you're going to see that reality. I mean, we've seen it before. We've seen it tons and tons of times before, but that continues to be a defining characteristic of the technology economy and marketplace. And so as the DOJ proposes some of these remedies, it and you know, even giving them all the benefit in the world in terms of their intentions, the reality is that if this is not, you know, considered carefully and frankly in a more sophisticated way that's informed by just even recent history, then we risk doing decisive damage, not just to our market, which is real enough, but to the overall kind of technological innovation base of the United States, which is a prerequisite for our nation's economic and national security.
Yeah, and I think the one thing that I want to sort of take off on that Klon just said is this issue of size and success being synonymous with sort of antitrust behavior or competitive violations. It simply isn't true. It's kind of the animating theory right behind a lot of the legislation that Congress has been doing. It's kind of the animating theory behind the way that Europe is approaching competition questions in their jurisdiction as well. They seem to sort of assume that because American companies have been so successful, or specific American companies, whether it's Google or Facebook or Amazon or Apple, right, because they're large and have succeeded and have grown to scale, that's a reason for treating them differently, changing the traditional rules of antitrust law as Acquia would, or as Europe is doing, both through enforcement proceedings, but also through potential legislative action as well. Um, that there's simply no basis for assuming that, right? In fact, to the contrary, what it does is it creates exactly the wrong incentives for small companies, startups, the ones who you want to scale. People forget that back in the day, Amazon was a small company. Back in the day, Apple was a small company. Back in the day, Google was a small company, right? There are the stories that we remember of Woz and Steve Jobs starting that company in their garage right after dropping out of school to do it, right? I mean, people forget that that's how these companies began, and they did grow and they did expand. They became successful. Apple went through a number of failures and successes over time. Jobs was fired, then hired, then fired, then hired again, right? I mean, people forget about that history that a lot of these companies have. And so this idea somehow that just because you scale up, that you're inherently violating the law. I mean, that's just contrary to traditional American notions of success and scaling and capability, and the heart of what we believe is a capital-driven society. And it creates the wrong incentives to these small startups who say, well, if you just grow big enough, if you just have enough customers, right, then we'll treat you differently. If you're just the right size, we'll treat you differently and apply different rules to you simply because you've been successful. And that's just a recipe designed for failure that will bring the system down upon itself, and a place that I don't think we want to go as a nation. So it goes a little far afield of the specific case that we're talking about now, but it talks, I think, about this larger sort of motivating thesis behind where a lot of the political debates are coming from when it comes to these larger companies that have been successful. Just because you're successful doesn't mean you're anti-competitively excluding others from the marketplace. And it doesn't mean that you shouldn't invest in new capabilities like AI. And by the way, let's just look at the scoreboard right now when it comes to Google's AI capabilities as compared to others. Yes, they had some of the earliest papers. They still have some of the most forward-leaning papers in this domain. DeepMind and the people who built that and who are innovating at Google are doing great things. They're not the leader in AI. A startup company, OpenAI, is accelerated well ahead of them. Anthropic is in the game as well. Shield is in the game. So this idea somehow that it's just the big players who have entrenched success, right, and aren't use that market power necessarily to succeed just because they're building new capabilities doesn't mean they're going to win, and they may not win. And in this case, right now, Gemini for a minute was the hottest thing out there, but it isn't today. It hasn't been, frankly, for a while, in part because Google responding to a potential regulatory environment has actually necked down their own capabilities, which query whether that's the right approach and whether the right solution for innovation in this country also.
Yeah, we've spent a fair amount of time on U.S. versus Google so far, and for the right reason, I think. I'm curious though, and Jamil kind of alluded to this. It's kind of a broader trend. Like we see this playing out in legislative activities, internationally, and even other court cases, perhaps. And Tom, maybe like how do we see this playing out against other companies, notably other tech companies? Court cases, I should say.
Yeah, court cases. I mean, the one that immediately pops to mind to me, and I'd be very interested to hear what Klon and Jamil think about this one, is the Department of Justice lawsuit against Apple. It was filed in early 2024. And the crux of the government's theory of harm is that Apple has used its power over its mobile operating system to impede the development of technologies that could reduce people's dependence on their iPhones. Basically, the court or the complaint refers to these products as middleware products. Like if you had access to this middleware products that could operate on different mobile operating systems, you wouldn't be as tied into your iPhone, and you might switch over to an Android device. So the complaint talks about super apps that are apparently popular in Asia, but we don't use them very much in the US. And Apple has allegedly made it difficult to create super apps. Super apps are apps that host a whole lot of different functions. So you could get that app on your phone, and they're cross-platform. So if you have the app, it would work either on an iPhone or an Android phone. So you get that app, load it up with all the little programs that you want, and then transfer over to the other mobile operating system. You could go from an iPhone to an Android phone, and without really losing anything. So the government's claim is by thwarting the development of super apps, we're preventing this sort of cross-platform functionality that would lead people to maybe switch over to Android. You've probably read in the paper about the complaint about the cross-platform messaging services, the sort of green bubble stigma. Elizabeth Warren made a lot of this, which I thought was kind of funny, but the idea that Apple punishes people that use Android phones by giving them green bubbles, and so people don't want the green bubble, so they buy an iPhone instead of having an Android. Apple has impeded the development of cross-platform digital wallets, the government says. So it disallows the use of its near-field communication technology. That's the technology that you use for tap to pay. And it's not allowing other digital wallets to use that technology. And so those other digital wallets aren't really taking off. But the idea was that if we had these cross-platform digital wallets, then people wouldn't be so locked into their iPhones. So in any event, this lawsuit really seems aimed at getting Apple to open up its ecosystem to allow others to build programs, applications essentially that would work cross-platform, so that people wouldn't be so tied into their iPhones and might be more likely to switch to an Android phone. And it seems to me that this has very significant security implications. It's basically requiring Apple to give up a whole lot of control over who can access its platform and who can access very sensitive features of its platform. So that one strikes me as really raising this tension. Another one that raises this tension is the lawsuit brought by Epic Games against Google. This is a really kind of interesting case. Epic Games makes the Fortnite video game, and they sued both Apple and Google over their App Store policies. And Apple actually won the lawsuit and prevailed on appeal as well. And so basically, Apple can continue to have its closed app ecosystem. You can't get an app for an iPhone except through Apple's App Store. Ironically, Google, which has a less restrictive app system, you can get Android apps outside of Google's Play Store. But that case went to a jury, and the jury found that that was actually an antitrust violation, which makes zero sense, that the more restrictive system is not an antitrust violation and the less restrictive system is. But in any event, the court in the Epic Games case recently issued a remedy that requires Google Play, the Play Store or the App Store for Google, to allow competing Android app stores in the Google Play Store to be distributed, and allow those competing app stores to access Google Play's catalog of apps. And that to me also seems like it carries some significant privacy and security risks. So those are two that pop to mind. There are probably others, but those are I think the two most prominent.
No, I appreciate it. Yeah, two good examples, I think. Jamil or Quan, do you have any thoughts on either one of those cases, or just broader themes even?
Well, you know where super apps are really popular? China. You know why they're super popular? Because they require broad access on whatever platform upon which they're being run. You know why they're not popular in the United States? Because we have privacy, right? Because users actually want privacy, or to put it more specifically, users time and time and time again have made the decision that as much as they talk about complaints about their data being used, they're actually far more comfortable with companies like Apple and Google having their information than they are with the government, which is frankly quite in keeping with our kind of national culture, historically speaking. If I'm, I won't comment on either of those specific antitrust cases because I'm not a lawyer. But if I were designing some type of a mobile platform, and I wanted to encourage massive user adoption, my first, second, and third promise to them would be data security, and that I was going to do everything I could to ensure that any application that uses our platform or runs on that platform has gone through a type of vetting and meets a minimum level standard of security and privacy before we ever let it near one of you, our most valued customers. And that's precisely what these companies are doing. Now, in different ways, Apple has chosen one line and Google has chosen another, but they both make the same fundamental promise, right, about security and about what's being deployed on their platforms. And that to me seems eminently reasonable. And this is one of those cases when the government comes in and points a finger at those types of actions and calls them anti-competitive. That to me just demonstrates a profound ignorance in terms of how this stuff works, why users purchase the services and features that they purchase. And I don't think you can, I personally don't think that you can look at the technology industry and say that it's not massively competitive. Now, maybe that competition doesn't look like somebody thinks it should. So I'm sorry if a user feels, I mean, I don't want to minimize this, but it is a pretty minimal thing, frankly. I'm sorry you don't feel good that your message bubble is green. Like, sorry that I don't know how significant of an issue is. You know what you're doing though? Your ability to communicate across platforms, you can talk to anybody you want. You can talk to them via voice. You can talk to them. You can share photos. You can talk to them via text, right? And that's all coming to you, right? In one sense, free of charge. And so there's no lack of technological capability or opportunity being put on offer here. And I just find this type of conversation where people are reaching for the colors of message bubbles to just demonstrate the kind of, frankly, the silliness of parts of this conversation. Now, again, that is not to diminish and dismiss all of this conversation, but these particular lines of inquiry I find just uncompelling.
Yeah, and by the way, even if you assume that there's some big problem here, and you're really lacking access to some sort of capability that you want, there's an app that Apple hasn't allowed into its app store that you can't get access to because you decided to buy an iPhone because Apple decided for whatever reason it doesn't meet their security criteria or the like, right? You have to look at what the flip side of that is, right? There's a reason why people buy iPhones versus Android phones, right? They want the ease of use, they want the the ease of deployment, they want you just sort of turn it on and it works. I don't have to mess with it, right? People who buy Androids, I want to be able to innovate. I want to be able to try different things. I want to try products that are, off the Google Play Store, right? There are different reasons why people buy these different products. And a lot of it turns on their desire for a certain level of customizability and like. And that's why you have robust marketplaces for both. And let's say you said, okay, well, there's a real problem here. We really don't like this. You've got to open yourself up, whether it's, the Google Play Store, you got to open yourself up in a certain way, or you got to allow, Apple's got to allow side loading, whatever the thing is, right? So you're requiring them to now say, hey, we created a very secure environment that we like for our customers, that our customers want and are paying extra money for or different money for. And we're going to tell them, no, you actually can't have that. You have to let all the Chinese apps, all the potentially deeply flawed or potentially problematic apps into your ecosystem, allow people to load them if they want to, because that's better for consumers. Well, part of me is saying so, but consumers clearly don't think that's better for them, right? Otherwise, they wouldn't be buying these products and sort of looking for that kind of capability. But on top of that, let's say okay, it was even more simple. You don't have to let in every app, but you've got to unbundle, let them have access to the APIs and all the other various things, right? So they can build in and integrate into your ecosystem. Okay, well, we saw how that played out in CrowdStrike, right? You require forced deep access to core operating systems, and sometimes things break, right? Worse, even worse, let's say you have a malicious actor, I don't know, call it the Chinese government or any of their state-owned enterprises. Now they're required to be allowed to plug into the APIs, the core systems, and the like, and bake in the potential access points, potential vulnerabilities, and the like. That doesn't seem like a good idea for consumers. Doesn't seem like a good idea for U.S. economic security, and certainly doesn't seem like a good idea for U.S. national security. And yet we're doing it all in the name of consumer benefit without applying the traditional consumer welfare standard that's an antitrust law. Because if we apply that, we have the system we have today. So we got to change the rules to get an outcome that nobody actually wants.
Yeah, no, thank you both. We've about 8 minutes or so left. So if you have, final questions for anybody listening, by all means, please submit them because we have a ton we can talk about. But I will say, just to make sure we get to and we can circle back to audience questions afterward is, obviously we're about a week past an election now. So what should we expect moving forward, both perhaps from a new administration, perhaps from the DOJ or the FTC, and then we haven't gotten to legislative options so far in this panel, but perhaps from Congress. So anything is fair game, forward-looking and 2025 focused. And whoever wants to kick us off.
Man, if I knew what a Trump administration would look like and we're able to get it right, going forward, I'd be a wealthy person. I mean, I think what people ought to be surprised by, let's talk about the new administration, is already some of the names that we've seen that are broken, that have come out both from President Trump himself, from his transition team, and have leaked out, I think are surprising a lot of people, right? I think at least on the national security side, you see names like Mike Waltz, which maybe isn't that surprising, right? Marco Rubio, which I think is fairly surprising. Elise Stefanik, maybe not surprising, but maybe for the position she was picked for, UN ambassador. I think there's a lot of interesting things happening that I think a lot of people had a lot more concern about. Now, that doesn't mean that we won't see people that people were concerned about in the Trump administration, or that we won't see policies that change. But remember, Donald Trump, not necessarily lock, stock, and barrel one particular agenda or one particular point of view. I mean, he changed his view on things like 702 during the course of a couple of months in his administration. Right, his administration was seeking to reauthorize 702. He tweeted out he thought it ought not be reauthorized. He was for the TikTok ban before he was on the campaign trail against the TikTok ban. Right, we're hearing rumors even today that he may change his views on antitrust going forward. So, as far as a new administration goes, I think it's a very hard thing to assess at this time, and may even be a hard thing to assess even after the administration takes position A, because it may switch to position B. And I'd say the same thing about Congress today. We have a whole new Congress coming in the House. We have a third of the Senate being reelected, a change in leadership in the Senate, a continuation of what looks like a continuation of Republican leadership in the House, but with a very different mix of Republicans. And so I don't think it is not obvious to me, and which is why I think people like Klon and other folks get paid a lot of money to figure this out. It's not clear to me where we're going to end up on a lot of these things. I will say, undoubtedly, there will be a change in policy and a change in implementation of how these things are going at the Justice Department and at the FTC going forward. When and how that happens and what it looks like, I think remains very unclear to me.
Yeah, I think the only thing I'll add there is it is my expectation that FTC Chair Lina Khan probably is not long for the Trump administration. And I think that will inherently change the posture of the U.S. government on some of these issues, at least in some significant ways. I mean, just to put a fine point on that, it was FTC Chair Khan who was sending US bureaucrats to the European Union to assist them in implementing their regulatory actions against American technology companies. I don't think that's likely to continue under the Trump administration. Now, that is not to say that there isn't significant skepticism within the Trump administration toward some large technology companies, and I'm sure that these companies are going to have to navigate that. But just in terms of general assumptions that have been kind of operative up until this point, I think many of those go away. I also think, as Jamil mentioned, just based on the personnel that's being named thus far, I think there will be a broad sophistication and understanding how these types of issues actually intersect with national security and foreign policy, particularly in the context of our nation's relationship with China.
How many thoughts, especially from like a court angle? Should we expect more of these types of cases? I know that's hard to predict, though.
I really have no idea. I think Lena is probably gone from as FTC chair. Her term's up, but I think she won't be renewed. And so we'll see some change at the commission. And one thing I think that's different about Trump 2 than Trump 1 that may be significant, especially when it comes to the tech platforms, is Elon Musk's purchase of Twitter. There was a period there where really the major tech platforms honestly were all biased against conservatives. And I think that motivated a lot of sort of anti-tech sentiment among people on the right. That it seems to me that has died down quite a bit now that there is one social media platform that's very friendly to conservatives, friendly to free speech generally. And so I don't know, it'll be interesting to see. JD Vance has expressed admiration for Lena Khan, and his sort of populist leanings are right in line with her views, I think. But a lot of the issues that we're discussing here arise from refocusing antitrust, and I think Jamil has made this point, but refocusing antitrust from being focused on the protection of consumer welfare, which is what the law is and what the courts, the enforcers have done for the last 25, 30 years, but refocusing away from that toward the protection of small competitors. And so, we were trying to create all these interoperability mandates and forced sharing and all that sort of stuff to give small firms a leg up. And that I think is a real problem. And the big question is going to be, are the new enforcers on board with that approach? That is the approach that the neo-Brandeisians, that Lena Khan and Jonathan Cantor, who heads up the Justice Department, that's their approach. But it hasn't succeeded very much in the courts so far. And I don't think that the Trump administration is probably going to have the tolerance to just continue to lose in court on these things. So I would expect to see us shifting back to a more traditional antitrust that focuses more on consumer welfare, and that'll be better for these security concerns.
Well, thank you. Yeah, unfortunately, I know we're about a minute left. If there's anything like burning that you haven't covered that you're like, we have to get in, feel free to flag it now. But if not, we'll have to circle back this sometime, because there'll be certainly a lot to talk about on this front in 2025, no doubt. But yeah, seeing none, I really appreciate the three of your time today. It's been super helpful. I love following this, and I took notes myself, so this is wonderful. And of course to Elizabeth and the Federal Society for coordinating this and the other exceptional programs you do. So I'll end it there from my end. Maybe Elizabeth, back to you if you have anything final to close us out.
Great. Thank you, Brandon. Thank you for moderating. That was a fantastic discussion. Thank you to all of our panelists. Again, on behalf of the Federal Society and the Regulatory Transparency Project, we really appreciate your time and for sharing your insights with us today. And of course, thank you again to our audience for joining us and for submitting your questions. And if you're looking for more content like this from the Regulatory Transparency Project discussing the regulatory state and the American way of life, please visit us at regproject.org. It's regproject.org. Thank you so much.